He can't win.
One will return to order here. Next section of the hearing, and we'll move into rebuttal. This is rebuttal evidence and cross-examination by the applicant. Mr. Baxter.
Ms. Zimmerman, can I don't sit down? So there was a slide, and Mr. Silliman, can you get that slide? Is this the slide you were? This is your presentation, right?
That's correct.
Okay. So there's been some discussion about this, and he's put in blue, this is an unsignalized intersection. In the second bullet point, he says the left turn movement in question is not a stop controlled approach at this intersection, which I believe his testimony was that is not applicable. Do you agree or disagree with that statement?
I disagree with his interpretation of this. The capacity analysis is the only determination for stop-controlled approaches. There is no chart for looking at the left turn volume on a stop-controlled intersection. The only decision made for a stop-controlled is based on the capacity. So if we were talking about the exit movement from Ballard Vista, whether we're turning left or turning right, the decision as to whether or not we would add a left turn lane on that approach is based upon the capacity of the analysis. It does not say capacity analysis should only be used there. It just says that it should be used on the stop controlled approach, that is the criteria for making a decision on a stop controlled approach is the capacity. It does not say do not examine the capacity of the uncontrolled approach.
Thank you, ma'am. Mr. Vincent, could you come up, please? Mr. Vincent, you heard Mr. Silliman's testimony about what he says was 300 feet of sight distance at this particular intersection. Do you have any drawings or anything that show what's going on here, and explain how it is that you came up with a different figure about the sight distances?
Okay. Let me go back to the testimony that I made earlier in introducing this email from the Highway Department. Again, I was there on Friday with both CWC Moore and Jason Richardson. I was in the vehicle. They have a measuring device in the vehicle where they push a button when they see the object that they're looking for, and then they hit the button when you stop. When that happened, this is what they sent back to me in an email. The sight distance heading west towards the Grange is 1,060 feet, and going away from the Grange is 585 feet. Now, you heard testimony from Mr. Silliman concerning the stopping sight distance here at the site, and he brought up some safety concerns. And I'm in agreement that there is some issues there with the stopping sight distance, but let's talk about why that is the case. This drawing right here shows that a vehicle that is stopped at the intersection and the sight distance going back, if you come back to 300 feet, as Mr. Silliman said that he measured, that would put you right here, which is near the second entrance into this existing house that's here. That sight line is impeded by an existing brush pile that is here and by vegetation that is on either side of that brush pile. I've got a couple pictures here that I think will show that. So the sight line that we're talking about is roughly right through the middle of this pile of debris. What happened is in a storm sometime, I don't know how long ago it was, but there were some limbs that fell down. Those limbs were cut up and they were put here next to the road. You can see in the picture that those limbs have been there for a while. So if we've got safety concerns here, why hasn't someone contacted the highway department and said, hey, we need to move that? But in addition to that, the other issue that we have is vegetation that is grown here north of this existing tree that's here. That vegetation was removed back in 2002 when we originally constructed the intersection. That vegetation needs to be removed. If that vegetation is removed, then the scenario completely changes. Real quick, before I get to that though, here is another picture showing that same debris pile and the vegetation that is impeding the line of sight.
And just so that we're clear, so you have roadway width, which is the pavement width, and then you have the right-of-way, which is area that is controlled by the state as well, correct?
That's right.
And how much typically is the right-of-way, does it go from the edge of the roadway?
20 feet.
So that's an area that could be cleared, and actually KYTC has jurisdiction over that 20-foot right-of-way, correct?
That is correct.
So they could clear all of that?
Absolutely.
Okay, go ahead.
Yes. All right, here is the second graphical picture that I have. Again, this shows the same stopped vehicle at the intersection. You've got that same 300 feet of sight distance. And then if you look down below it, you'll see the required stopping sight distance of 490 feet from here to here. Now, when you do that, it's important to note that there's the existing 30-inch tree that's here, and I've surveyed this is a graphically accurate picture of what is actually there and what was there in 2002. And we cleared that bank along that line of sight, just on the north side of that tree, so that you would have adequate stopping sight distance from the intersection back 490 feet. Couple more pictures showing the debris pile. It's a little bit difficult to see, but I've got a 8-foot long measuring stick that shows that the breadth of that debris is 8 feet. Here's another picture showing that debris, again, 8 feet in width. The height of the obstruction, according to the KYTC 902.8, that you're looking for is measured at a height of 3.5 feet. That debris pile that is there, if you look closely, you'll see that at the highest point, it's 4 feet, which is right there on the stick there. So the entire debris pile was not 4 feet high, but the majority of it is, or a significant portion of it, is above that 3.5 foot measurement. There's one more picture, again, depicting the large amount of vegetation that's just north of that existing 30-inch tree, the debris pile. All of this needs to be removed. Now, moving forward, that is an analysis of the stopping sight distance coming into the intersection. We have similar conditions looking to the east. You've got traffic that is coming from the west, that is the opposing traffic that we're worried about when we turn left. We have similar conditions that are, again, further to the east with vegetation that needs to be removed. That vegetation wasn't there in 2002. The agreement that we had with the highway department is that we would plant ivy. The ivy has been planted. Some of it, it's 15, 17 years ago. Some of it is not completely there anymore, and grass has been allowed to grow up. Tree limbs are starting to grow out towards the highway. This whole area needs major maintenance. There's no question about it. But the point that I'm trying to make is that can be done economically. It can be done very feasibly so that the sight distance can return to the original conditions that we had in 2002 where we got the original permit.
Thank you, Mr. Vincent. Mr. Silliman, can I ask you a couple questions? Yes. Would you approach, please, if you don't mind? Yes. Do you disagree with Mr. Van Zandt's conclusions that if all that debris was cleaned up, it would improve the sight line?
I think it would improve it, yes.
Is another possible solution to your stopping distance concerns to reduce the speed limit in this area?
Yes.
Do you know if anyone from the county engineer's office has approached KYTC about reducing the speed limit in this area?
I have not.
Has anybody in the engineering department received complaints from any of the residents of Ballard Woods or anyone about cleaning up the debris that is piled on the side of the roadway?
I'm not aware of that, but I would like to research our records because there's a lot of complaints we get.
And at this point, you haven't called the highway department and said, guys, can you go out there? This is part of your right of way. You need to clean that up.
Not at this point, no.
Okay, is that something that you could do?
Yes.
Further, is it something that you could do to request that they reduce the speed limit in this area?
I could request it, but I can't guarantee any outcome on that.
Would all of those things improve the safety condition at this intersection?
Yes.
Is it your testimony today that regardless of whether my client builds or doesn't build this subdivision, that this is an unsafe intersection?
I think improvements need to be made.
So if they don't build this, improvements still need to be made regardless?
Yes.
Mr. Chairman, that's all the questions I have.
Thank you, Mr. Baxter. We will now move into rebuttal and evidence cross-examination by those opposed to this application. Does anyone wish to provide rebuttal or cross-exam?
Hi there, thank you for your time here today. What we would like to state is the debris. That's new information, and I appreciate pointing that out. We'll certainly put in a formal concern and request to get that removed. However, I would like to go back to the aerial view of that 130-degree angle. The reason I have personally not called about the debris is because that is not the issue. The line of sight will not improve drastically enough to prevent the jackknife trailers that are coming behind us, to prevent the excessive speed of those that are behind us. It is a 45-mile marked curve today. Okay, so if you reduce to 45, that is what it is today. And that is still going to be a very dangerous curve. So I hope you would appreciate all the information that we've shared in that regard. Okay, thank you very much.
Thank you. All right. Moving into final statement, Ms. Guilfoyle, we're looking for a final statement from opposition or from those opposed to the application. Do you have anything to add? Thank you. Mr. Baxter, final statements?
Mr. Chairman, I thank you all for your time today. Just so that we are clear, this is a procedural right. I mean, the application to amend a binding element, I didn't just make this up. I mean, I went to the website of the Planning and Development Services and downloaded the application. So this is not, I realize you all don't see a lot of these, but I've been before you on one of these applications before when it had to do with some brick facing and how much brick facing had to be on the side of a house, which you all don't concern yourself with anymore, but it was a concern way back when, I think in 2005. What you have before you today is an application to remove a binding element that is put in place here, that the wording of that binding element indicates that based upon the conditions that existed at the time, which it was incorrect, that the left turn lane was warranted at this particular location. Now, I do want you to think about one thing. Mr. Silliman stood up here and he testified. He is the county engineer, and he testified that regardless of whether or not Ballard Woods Section 5 gets built, that this is an unsafe intersection. In other words, this is not a condition that my client is creating. It's something that needs to be addressed. And what we're being asked to do is we're being asked to spend $630,000, which is what Mr. Van Zandt said conservatively, to fix a problem that exists at this point that we did not create. And we're being asked to do it now, even though the traffic engineer, your all's traffic engineer, our traffic engineer, said that it's not necessary as we sit here today. You have the highway department, which was asked, and they said they weren't requiring turn lanes at this particular location. And that's been their viewpoint the whole way through. And now you have clarification by your own traffic engineer that indicates that they are not required as we stand here right now. So we have a problem. And the problem is not a problem that we created. There are solutions to the problem that can be had, but there is not any testimony that you all received that anyone has done anything to fix this problem up until now. There hasn't been any calls to the transportation cabinet. There hasn't been any request that this debris pile be moved. There hasn't been any request that the tree that is in the right-of-way be cut down. All of those things are solutions. Reducing the speed limit is a solution, but nobody is asked to do that. So now the solution is to have a private developer spend over $600,000 to fix something that is an existing problem that we didn't create, and that's the solution. That certainly doesn't seem like a fair resolution, and it doesn't seem like something that ought to have to happen. And to be frank with you, if the binding element number 5 stays in place, I doubt the subdivision will get built, because that adds about $9,000 a lot to each one of the lots in the subdivision to the price of it, which is just going to be economically unfeasible. So if that's your all's position, then understand that my client is not going to fix the problem, and the problem's still going to be there. Further, based upon the way the regulations are written, they shouldn't have been required to do this in the first place. So under the existing regulations that you all have to apply, they should not have been required to do this. And that would be our position. And Mr. Chairman, I thank you for your time.
Thank you, Mr. Baxter. Mr. Urban? Procedurally, where are we headed next?
Well, you can close the public comment period if you want. You
Well,
can-
let's do that first. We're going to close public comment.
Okay, that's the
Right.
next piece, and then it's just a matter of deliberation among the commissioners.
All right. Mr. Combs, can you provide some background and framework for the commission in terms of placing of binding elements on an application and whether or not there's any prerequisite for concurrence when it comes to those binding elements?
In my opinion, that's what your job is to do when the testimony is presented based on the application. And if you feel that other binding elements are necessary that may not have been indicated at the beginning of the proceedings, and we do this frequently, in my opinion, you have a right to include those or make it a part of your motion and a part of the approval or disapproval of something. I don't have a doubt about that. And it appears that that was done through the motion that was made in the last, what I can glean from this, there was discussion during the original testimony regarding the necessity of a left turn lane or how it might impact this overall plan. And at the end of the proceedings, Mr. Falvey's motion was to add a binding element, and it was part of your motion, and it was approved. Now, I'm not going to address at this point whether or not Mr. Baxter should have objected or saying, procedurally, you've heard all this today. So if there was a mistake made back then or an error in procedure then or due process, I think today's proceeding has clarified that and clears the way for you to make a determination based on the motion today. Do you wish to remove it at this point or make it part of the project? So-
Which is indeed what the request is
Correct.
can we remove this?
Right.
Okay, all right. Okay, so we will now open the floor for motions with respect to this application. Mr. Urban, can you frame up the decision, then we are looking at, and maybe just correct me if I'm wrong, we are looking for a motion to determine whether or not this application should be moved forward for approval, correct?
Right, either a vote to remove the binding element or leave it in place. And I think it's that simple.
Okay. Chair will accept motions from the floor.
And, you know, and you would base that on the evidence and testimony heard on both sides of the argument.
Ms. Davis? We have a motion on the floor. Counsel, is that adequate?
Fair? Yes.
A motion on the floor. Do we have a second? We have a second. We'll move into roll call vote.
Well, discussion.
Excuse me. Thank you. Discussion? Mr. Douglas?
The only thing I want a clarification on, just to make sure on discussion. Based on the Oldham County subdivision regulations, section 5.3, point C dash, or point 6C, and it talks about turning lanes and what the developers are supposed to do and shall obtain and dedicate sufficient right-of-way and constructing turn lanes as necessary. I'm not sure I heard enough testimony, but I think maybe others have, maybe I missed it. Whenever a proposed subdivision or additional section of an existing subdivision generates an ADT of 1,000 vehicles or greater, and are approved by the Kentucky Transportation Cabinet or county engineer. So, were they over 1,000, or is it 1,000 over 2025? Never got a clear answer. I was waiting for somebody to provide that.
Well,
But I know there was, in January of 2019, there was conversations about the ADTs. So just want a clarification from that motion that,
well, I'm looking at the original traffic impact study. That's where that's where it's determined how many trips are generated by the 87 lots. And typically, we say there's generally 9.6 trips per day generated by each single-family residence. So at 87, I'm not doing the math, it's under the 1,000. So that evidence was actually presented in the original case, and I'd have to stop talking and read
okay.
the original analysis to come up with what that answer was.
That's all I had for discussion.
All right. Further discussion. Mr. Falvey?
Along the same lines, if you look at the technical memorandum that was done in January 22nd, that he just referred to, and it does give what the developer is supposed to do, and it also gives the traffic counts that are projected, and they're going to be the 2025 build for Ballard Vista Drive is 1434, and Ballard Glen Parkway will be 1625.
Thank you, Mr. Falvey. Further discussion. Mr. Finney?
On the sight lines and questions we have here, Amy, you're probably the most expert person to ask this because you've traveled this road at least twice. Coming,
Well, wait a minute, now
I don't think I can give testimony.
Just sit down. No.
Just
He can ask me a
clarification.
question.
No, we can't. Public, comment is, no, you cannot ask questions. We have closed the floor.
Sorry,
Okay.
Mr. Finney.
You
All right.
can't- You can't ask questions.
All right. Further discussion. All right. We'll move into the roll call vote.
Do
Well,
we have a second yet?
yeah, there was a,
Yeah, I missed all that with the
okay,
next.
Hang on 1 minute. Mr. Hampton, did you have something?
I'd just like to clarify exactly what a yes vote is on this.
This is a motion to deny.
no.
Oh, excuse me.
No,
This
that's
is
not
a
what you
motion
said.
to approve.
To remove,
This is to approve.
So a yes vote,
removes the binding
Removes the
element.
binding
Thank-
element.
thank you.
Good point. is done.
Okay, Ms. Davis. Mr. Douglas.
Yes.
Mr. Falvey.
No,
Mr. Finney.
No.
Mr. Halfling.
No.
Mr. Hampton.
No.
Mr. Elder. Yes. Mr. Neal.
no,
Ms. Smith. No. Ms. Nasser.
No.
All right, so our motion has failed by a vote of 7-3. Council?
Well, so I was asking him the question is it necessary to make a different motion now, or is it stand as,
Well, was that vote?
it was.
This was a motion
turned
to
down.
approve that failed.
Well, then it's still of record. I mean, it's still a binding element at this point. There's no reason to make any further motion that I can think of, but if you all.
Thank you. Mr. Baxter, your application has been denied. Thank you, Mr. Chairman. We'll close our hearing. The preference of the commission, we have, what's left on our docket today? All right.
County attorney right now for the week. I have 2 trials scheduled to begin at 1 o'clock today over in district court on disability matters. So if we could do these others within the next hour, I would
Well, the other ones-
appreciate doing that. I don't know how
the
long
next
it's gonna
one might
take.
take a little longer than an hour. But I think you're fine to, I think we can fly on our own.
Well, and if you need me,
Right.
I can address it, well, you can just
think the
call me.
next
I'm gonna be back and forth, so.
The next 2 items we can do on our own.
Okay. All right,
got a lot
for the
on my
commission, we
plate
are
right
going
now.
to, we're going to break for an hour, grab a bite,
Yeah.
reconvene at 1.
Yeah. I may not be here, but I'll be
I
available.
think we'll be okay for the next.
You can call me if you need me. Unless I can get, the only other prosecutor that can cover this is